Okay, so let's talk about this. A lot of people want to know what's the scariest or most dangerous part of a Social Security disability hearing. Now, we're going to go right into it, but please remember to like and subscribe. And when you subscribe, click the all button. With that said, okay, the thing you have to realize is that there are common types of hearings and uncommon types of hearings. Uncommon types of hearings have 5 steps to them. Common types of hearings have 4 steps to them. Let's talk about what's uncommon with that one extra step. With the one extra step, it's where they bring a medical expert to the hearing to go ahead and give testimony about whether or not the claimant is severely impaired. Okay, so what do we mean by that? They bring a doctorate level or a doctor of some sort to the hearing to give testimony right after the intro that the judge has with the attorney. So, under an uncommon layout for a disability hearing with the 5 actual steps, there's the intro where the judge talks to the attorney. The medical expert gives testimony about the claimant's limitations. They get the medical expert in and out. And then they have the claimant's testimony, vocational expert's testimony, and then the outro of the claim. Now, the deal is this: when it comes to a more traditional hearing, what usually happens is the intro administrative portion, then we get basically to the claimant's testimony, then we get to the vocational expert's testimony, and then we get to the outro of the hearing. So, right in here represents the unusual hearing with the extra step being with the medical expert. Now, what's most dangerous for the unusual situation where there's 5 steps to that hearing is the medical expert testimony. And the reason why is judges tend to heavily rely on the testimony of that particular judge or that particular medical expert right then and there to give guidance as to which way the claim should go medically. Now, if the medical expert says that the claimant is severely impaired, has these limitations, they wouldn't be able to do this, this, or this, cool. The claimant will likely be found disabled. The judge will nod at the attorney saying, hey, let's keep this quick. And then you'll go forward. If the medical expert comes forward and says, well, could probably do this, this is not showing to be that severe, only has these documented limitations, could probably do this, could probably do that, etc., then you have a knockout, drag out fight. But it should be considered the most dangerous part of a hearing because the judge, fresh in their ear, has a doctorate or postdoctorate level individual giving testimony that the claimant should medically not be found disabled for that particular impairment, which is almost always the headliner impairment or the flagship impairment. What do I mean by flagship impairment? Everybody usually has a couple of impairments, right? But there's usually one that's the absolute worst one. For VA people, it's their highest percentage impairment. For civilian based people, it's the impairment that limits their ability to work the most, okay? So, or causes them the most pain or some symptom that limits them the most. So, as a result of that, what happens is if you have an unusual hearing, it's the medical expert testimony that should be the most fearsome, the most scary and dangerous. But if you have a regular hearing where there's no medical expert, then in my opinion, the most scary part for Social Security claimants that are seeking disability benefits would be during part 2. Let's go through the 4 step again. Intro, testimony of the claimant, vocational expert testimony, and outro. It is specifically this one where the claimant is going ahead and giving testimony about their Social Security disability limitations. Okay. So basically, when they're seeking Social Security disability insurance or supplemental security income, and they're seeking to go ahead and get that monthly check on that insurance, it is step 2 that tends to be the most dangerous. Why? All right. I always call it the difference between a smooth hearing and a not smooth hearing. What do I mean by that? Well, what I mean is that when a claimant does not have preparation for how to answer questions when going in front of a Social Security disability judge, an ALJ at the OHO level, what happens is they don't give good answers. Now, I've stated before, and it's probably something I shouldn't have said, but I have said it. I don't do well with claimants in hearings that are very, very like not prepared. So, I think some attorneys do well with claimants that are not prepared at all. Those are the attorneys that don't prepare their claimants at all. They tend to do better with them. I do better with claimants that are heavily prepared because I really like having smooth hearings. When the judge is yelling at the claimant or yelling at the attorney, or the attorney feels or the claimant feels like something isn't being done right, That to me is not a smooth hearing. I don't like those. So some attorneys will be like, yeah, we want to have this aggressive, we want to have this, kind of battle going on and this fight between the attorney and the judge. Not so much. In disability land, the judge is not the neutral third party where there's an attorney on one side and an attorney on the other side. In disability land, the attorney and the claimant are on one side. And then over here, in what's considered to be, the non-adversarial process, the judge represents the SSA on this side with making the decision. So as a result of that, the kicker is the claimant's testimony is the most dangerous and severe and scary part of a traditional four-step Social Security disability hearing. Now, why is that? Claimants, when they're not able to be prepared, even the very intro question that usually comes out, they're not able to answer. So, for example, the intro question, they'll usually, okay, what's your name for the record? Cool. And then you'll do that at the hearing. Okay, date of birth, current age, left or right-handed, blah, blah, blah. You'll go through the intro testimony, right? The basic questions, establishing who you are. Then after that, what will happen is you'll usually get a question that opens us up to your impairments. So, for example, a question like that would be, why did you file for disability benefits when you did? What do you feel are your most severe impairments? What happened to your work and why did your impairments make you stop working, right? You'll get an opening intro question, okay? So now what I train my claimants with for, the classic thing like that is, okay, what are your top 5 impairments? When did each impairment begin? When did each impairment become severe and why? What are 2 signs/symptoms per each impairment? What are your medications and 2 side effects per each? And why can't you do the jobs, the functions at those jobs, right? You get to work, you had to do a function that you've done over the past 15 years, right? So you had 15 years worth of work. What were the functions that you used to do? This is the most basic intro crap that you have to know. And yet, almost every single claimant that I get from every other law firm or from out in the wild or from non-legal reps especially, they don't know how to answer those, which to me is weird because if you can't tell somebody what your impairments are, that's not a good spot to be when you're sitting in front of the judge who's going to decide your claim. I think this chair is going to drop me soon. The whole thing is just destroyed, but I have to tighten it. I just haven't had a chance. Now, with that said, okay, knowing the question and the answer. So let's go through a basic one real quick. The question will be, okay, you're in the hearing. The judge will say to you, why did you file for disability benefits when you did? Well, you can't really answer that question unless you know what your last job was. Why did the last job not work out? And you can't really answer that unless you know why your impairments are so severe right now that you had to file. And you can't really answer that unless you know what your symptoms are that resulted from your impairments, right? The symptoms and signs, like why are they so bad? And you can't really answer that unless you know what your damn impairments are, which is the weirdest thing. I've taken many big box, law firm claimants to hearings where I didn't get a chance and their hearing was like next week. I get them and the next week we're going in. I didn't get a chance to run a lot of hearing questions with them and they don't even know what their top 5 impairments are. And remember, top 5 impairments, that is a training question. So you can use it during a hearing, but it's a training question. The actual question is, what are the impairments that limit your ability to work in a traditional vocational setting? That is a competitive market situation. And so the idea is you're competing against other people for a job. You get the job, you have to work at the rate at which other people are able to work. How do your impairments limit your ability to do that? And you can't answer that unless you know exactly what your medical conditions are. If you walk into there like, I got pain in my knees. I got swelling in my knees. I got a wrist thing. I got a wrist thing. If you walk in and pull that crap, you're going to get a bad hearing because all of the questions that stem from it thereafter, right? All of the questions that come thereafter are based upon the fundamental of what you say up front. Now, I do have claimants that no matter what I do, they're not going to give me a good answer at a hearing. No matter what I do, they're not going to give me a good answer at the hearing, no matter what I do. Claimants that have this issue, right? Low intellectual quotient claimants, IQs in the 60s, 70s, 80s, low 90s, stuff like that. They can't remember how to answer things. They can't remember stuff. Even if they have a list in front of them, they're not sure how to read it. Okay. That's especially in your, IQs of the 60s and 70s. That's an issue. Then you have people who basically, when it comes to PTSD, when you start talking about their PTSD, their brain just erases. And whatever was up there, whatever's in the cloud bubble, just boop, it's gone. You'll see that from every type. You'll see that from the tiny little lady to like the 6 foot 7 hoorah marine. You see the whole spectrum with that, and it's just amazing. Their brain goes blank, and then you got to somehow get their brain to restart. You got to pull the cord on it to get the engine going again, which means you have to figure out what makes that person reconnect with reality during a hearing, which is another thing that not all attorneys learn about their claimants. That is so important because when a claimant starts to cry or lose it or go off to some place in their brain and they've got, schizoaffective, depression, anxiety, panic attacks, PTSD, mood disorders, bipolar, whatever, if they got those things, all of a sudden they're off in fairyland and you have to somehow grab their brain and pull it back into that small little area that it needs to perform in front of the administrative law judge. So to me, that's basically the scariest part because a claimant is really at the hearing to give testimony to either support, give neutral, or completely blow their opportunity to provide good evidence as to why they're disabled. And think about it. You could walk into a hearing, right? And I have claimants do this, right? They'll walk into the hearing and all of a sudden they'll start talking about how they love to work. They're getting a job tomorrow. They've been working under the table. Nobody knows about it. And boom, now we have a trust issue. Now we have a vocational issue. Now we have a tax issue, so on and so forth. The claim has died. Then I have claimants where they give me a middle road performance, doesn't help the claim, doesn't hurt the claim, it is what it is. We rely on the medical evidence and go forward from there. Then I get the claimants who give me a beautiful performance. And, some disabled will say, oh, no, it's real. There's no performance to it. Those are also in line. That is the group of people who are, and I hate to say, I don't want to use the word delusional, although it does fit. It is an accurate statement. Those are the people who believe that so long as you just tell the truth, magically everything will work out. You just got to tell the truth. No preparation needed. You don't need to know the questions ahead. Just tell the truth. You don't need to know your side effects or your conditions. Only if you're really disabled, you just tell the truth. Should just work out. Now, that whole generation of disabled who were found disabled, that whole generation is gone now. There's very few people who make that argument. And the reason why is that either those people who made that argument back in the day now realize it's much, much harder to get onto disability benefits. So the fluffy little pillow of falling onto it and getting found disabled, that's no more. The other option that has happened is that a lot of those, you just magically will be found disabled. Everything's amazing, right? Those individuals realistically have gone through a CDR and they've realized, oh, wait a minute, I might have to actually prepare and get things lined up correctly. And then, of course, the other thing is that many of them have aged out. They're now in retirement. The world of disability that they grew up in from 20, 30 years ago, it's just not the same. The rules are different. The standards are different. And most of all, the culture is different for approving people. So you don't get those people anymore for the most part. And it's good because those people would cause significant depression for essentially those new people who are disabled seeking benefits. Now, I'm not going to BS you. The bottom line is it's way harder to be found disabled now than it ever was. And the truth is a lot of those high percentage passage rate judges, especially the judges from back in the day, a lot of those judges that were older, they've retired now. The major amounts of those that still did exist, they retired during COVID. It ended. It's over. The high percent passage rate judges in the 70s and 80s, there's hardly any of them left. So the point is that there's unfortunately a section for the hearing that is very dangerous for the attorney, dangerous for the claimant, dangerous for the application process. And that is the section where the claimant can make statements. Now, if it's an unusual hearing and the medical expert is present, then the medical expert, in my opinion, is very likely the most dangerous part of the hearing. Now, I want to just finalize one particular thing here so that you understand it. The bonus round for being incredibly dangerous, and I always tell claimants this, at the very end of the hearing when the judge asks you, right at the very end. So you have the intro where you're talking, or where the attorney's talking to the judge, administrative housekeeping, testimony of the claimant, vocational expert testimony, and then the outro of the claim. This is the bonus round. At the final part of the hearing, when the judge asks the claimant, hey, is there anything that you'd like to add? Anything that we missed, any impairments? When the claimant goes into story mode, I have seen perfect win, absolute certain, definitively great claims go completely down the toilet. It is your job to learn that when you are presented with an open sandbox, it is your job to be smart about what you say. Think about it. You're not being asked a question about a particular thing. You're not being asked a question about bullet points that you can line up, but you have been given a sandbox that you can play in. So when you start talking about how you love to ride your Harley to North Dakota, or you love to go ahead and do, triathlons, or you like to go ahead and do this or that, or you've just, started selling things from your garden, please remember that you are the most powerful, destructive nuclear weapon in your disability hearing, because the things coming out of your mouth when you think you're making an emotional connection with the judge are likely going to hurt you. All right. I see Darren Lawson Hosking, $5 donation. Super duper thank you. Had hearing 40 days ago and approved. How long before I hear receive anything? Longer to swear in than hold hearing backdated to age 55 year prior. So cool. You got a grid out for 55 plus. You're 40 days, then approved. So that was a quick approval. Bottom line is this: you usually hear back and start receiving the funds from that approval letter within 3 weeks to a month. Sometimes it's 2 weeks, sometimes it's a month and a half. Usually you get your forward paycheck first and then your back paycheck. That's usually how it works. So 3 to 4 weeks, you should be getting stuff. All right. Now, with that said, real quick, I am going to be going ahead and doing the next video. I was not on phones today at the law firm, so I will be doing some phone calls. I'm going to be driving. I'm not going up to the farm. I saw some things there. That's a little bit later on down the line. I will catch you guys at the next video. The next video is basically about what your likely increase for Social Security benefits will be going into 2025. Now, with that said, please remember to like, subscribe, and if you get a chance, go to Google and type in Disability Resolution Florida or Disability Resolution Law Firm and throw some stars up there. I will catch you guys a little bit later. You have a wonderful, wonderful night, and we will go from there. Thanks so much. All right. Bye-bye, everybody. Bye-bye.